Slam dunk, are you ready to meet me? I'm here and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and right. You just never use it.
So this is session 1, the Sunday morning of the Walker Moot Supreme Court in the BLG courtroom. We would like to acknowledge that we are speaking to you from the traditional unceded territory of the Algonquin Anishinaabe people. We speak today while paying respect to the traditional knowledge keepers and the Algonquin peoples and all Indigenous peoples in the region of Ottawa who call the national capital their home. If you are not located in Ottawa and do not know about the traditional territory on which you are located, we encourage you to navigate to websites like nativeland.ca to find out. And we also encourage that you learn more about decolonization by consulting the TRC calls to action as a starting point. It is with great honor and privilege that I present Justice Grant Ferguson from Steiber Burlak LLP, Justice Daniel Chomsky from Dowling WLG, Justice Lydia Yemakova from Ladner Slat, Justice Dr. Breffany Hannon from Princess Margaret, and Justice Rhesus Crisblom from Ladner Slat. Pardon me. On October 19, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward of Fallview Health, 13 hours after her transfer from West Valley Memorial Hospital. Ms. Stark's medical records reveal she was in perfect health and she had no previous existing medical conditions, nor any prior family medical history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, 2021, Ms. Stark tested positive for COVID-19 and contacted her longtime physician, Dr. Sophie Strange, and obtained a prescription for ivermectin. Though all pharmacies in her area were out of stock, Ms. Stark's condition was stable. On October 5th, Ms. Stark was notified that her local pharmacy had just stocked on ivermectin and her prescription could be filled. But that same day, Ms. Stark had developed severe shortness of breath and mild hypoxia and was admitted to the defendant's hospital, where she was placed under the care of Dr. Myrtle Papadopoulos, a third-year medical resident. Ms. Stark immediately requested Dr. Papadopoulos administer the ivermectin her family physician had prescribed, a course of treatment which he chose to reject. On October 6th, Ms. Stark was moved into the ICU and placed on a nasal cannula during the day and a BiPAP at night. Ms. Stark was treated with the hospital's COVID-19 protocol, which consisted of dextromethasone and pure oxygen. On October 7th, ivermectin was administered after Ms. Stark's family pleaded with Dr. Papadopoulos. Within 11 hours, Ms. Stark's condition had improved greatly. However, the supervising physician on staff, Dr. Lutsier, chose to withhold any further administration after being informed of Dr. Papadopoulos' use of ivermectin. On the evening of October 8th, Ms. Stark's condition worsened and she was sedated, intubated, and put on a ventilator. Almost immediately thereafter, Dr. Lutsier was contacted by Dr. Strange, who strongly requested ivermectin continue to be administered in addition to the MATH Plus protocol. In response, Dr. Lutsier asked Dr. Strange to forward him the relevant literature for which she was relying on so that he can make a rational and educated decision, which was provided immediately after Dr. Lutsier determined his time would be better spent attending to his patients than reading what he referred to as propaganda. On October 10th, ICU nurse Delrose Patel was convinced by Ms. Stark's family to speak with Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel and to administer the frontline COVID-19 Critical Care Alliance MATH Plus protocol. Nurse Patel spoke with the attending physician, Dr. Andy Park, and convinced him to undertake Dr. Strange's request. Within 15 hours, Ms. Stark's ventilator was turned down, and Dr. Park and hospital personnel began the process of trying to bring her out of the medically induced coma. On October 11th, Ms. Stark's condition had improved, at this point having only to rely on a nasal cannula. On the morning of October 13th, Ms. Stark's family was informed by Nurse Patel that the hospital had misplaced the ivermectin, but there was no need for concern as Ms. Stark was making great progress. However, Dr. Luthier once again assumed care of Ms. Stark, and upon learning of the patient's treatment course, chastised Nurse Patel and the medical staff for administering the Math Plus protocol. Dr. Luthier then administered remdesivir to Ms. Stark. Nurse Patel phoned Ms. Stark's family and informed them that Dr. Luthier had assumed and denied any further administration of the Math Plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury as part of an initiative to help provide critical care to the patients battling COVID-19 in rural communities. At 1:27 a.m., Ms. Stark's oxygen level began to drop and she became unstable. Within 3 hours, Ms. Stark was placed on a ventilator. The family arrived at the hospital, but was denied access due to the hospital's COVID-19 protocol in place. Ms. Starks phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Luthier, but after 4 unsuccessful phone call attempts, decided to drive down to the defendant's hospital and attempt to manage the situation in person. Upon her arrival, Dr. Strange was denied access to Ms. Stark and was unable to speak with Dr. Luthier. Within 6 hours, Ms. Stark's chance of survival had dropped to 20%, and Dr. Luthier informed Ms. Stark that he had exhausted both his course of treatment and COVID-19 protocol in treating Ms. Stark. Mr. Stark pleaded with Dr. Luthier to administer the Math Plus protocol and offering to sign a release, releasing Dr. Luthier and the hospital of any of its agents and parties acting on its behalf from any and all liability arising from administering the Math Plus protocol to his wife. However, Dr. Luthier refused to administer Math Plus protocol, and a verbal confrontation ensued outside between Mr. Stark and medical staff, and security removed him from the building. On October 19th, Dr. Luthier agreed to transfer Ms. Stark to Fallview Health, where Dr. Strange was on staff and would therefore be able to assume care for her. However, less than 1 hour after arriving at Fallview Health, Ms. Stark died. In this matter, the questions at issue are the following. Issue A, standard of care. What is requisite standard of care for medical negligence in Canada as correctly applied to this case? Did Dr. Luthier breach the standard of care in failing to investigate the literature he was provided with and denying Ms. Stark treatment with the Math Plus over ivermectin alone? Issue B, did Dr. Luthier conduct, cause, or contribute to harm or injury Ms. Stark sustained? And issue C, vicarious liability. Is the hospital vicariously liable for Dr. Luthier's actions? Justices of the panel, I present to you speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Drayden Lee and Colleen Dowling. And speaking on behalf of the defendant, Dr. Luthier, and the West Valley Memorial Hospital, William Wang and Malik Tehaili. We are here today to determine the outcome on trial before the court on the matter between Mr. Stark, Dr. Luthier, and the West Valley Memorial Hospital. Both the plaintiff and defendant counsel will have 30 minutes each in total, 15 minutes each counsel member to present their arguments to this court, including answering questions from the bench. The plaintiff will present their arguments first, followed by the defendants, and then a 3-minute rebuttal may follow by the plaintiff if they choose to do so. I will signal to the court when there's 5 minutes left per speaker. The court now invites counsel for the plaintiff to begin.
Thank you. Good morning, honorable justices. My name is Drayden Lee. My colleague, Ms. Dowling, and I are representing the plaintiff, Mr. Stark, in the present matter. Today, I will be speaking about the requisite standard of care for medical negligence in Canada as correctly applied to this case. My co-counsel, Ms. Dowling, will then address the issue of causation and will conclude with a discussion of vicarious liability. Together, our submissions will demonstrate that the defendant, Dr. Luthier, was negligent in his care and treatment of Ms. Stark, and that his employer, West Valley Memorial Hospital, is vicariously liable for his negligent actions. I will defer to the facts as just stated. My submissions will make 2 main arguments. One, that Dr. Luthier breached the standard of care by failing to investigate the literature that he was provided with. And 2, that Dr. Luthier breached the standard of care by denying Ms. Stark treatment with Math Plus. Since it is our contention that Dr. Luthier was negligent in his care and treatment of Ms. Stark, let me begin by setting out the necessary components of negligence. A successful action in negligence requires 1, that the defendant owed a duty of care, 2, that the defendant's conduct breached the standard of care, and 3, that the defendant's breach caused damage in fact and in law. It is well established under the common law that a medical practitioner owes a duty of care to the patient. Therefore, I will focus my submissions on the requisite standard of care as correctly applied to this case. The test for standard of care in medical negligence is a test of reasonableness. As outlined in Cricks and Sylvester, every medical practitioner must bring a reasonable degree of skill, knowledge, and care to the task at hand. A practitioner is required to exercise the same degree of care and skill as would reasonably be expected from a normal, prudent practitioner of the same experience and standing. We would like to stress that the standard of care is based on reasonableness. Our submission is that it is unreasonable for a prudent medical practitioner in Canada to blindly follow protocol and to cast aside other methods of treatment as propaganda when that protocol is proven ineffective. This is supported by both the expert testimony and Canadian jurisprudence. Let me now turn to my first argument regarding investigation of the literature. During their testimony, Dr. Strange, Titchener, and Moriarty all agreed that the standard of care involved due diligence and an investigation of the literature to make an educated decision regarding treatment. I refer you to paragraph 38 of our factum. There you will note that when asked about the standard of care, Dr. Strange denied Dr. Lutzier's conduct was reasonable, prudent, and diligent. She specifically stated that the standard of care of a prudent physician would have been to review what I sent or conduct your own detailed investigation, then make a decision, an educated one, an evidence-based one. Dr. Titchener agreed with Dr. Strange that the standard of care involved conducting due diligence. Dr. Moriarty, who I remind the court is the expert for the defendant, took time to review the literature Dr. Strange provided to Dr. Lutzier. When asked whether it would be a breach of the standard of care for a physician who had access to those resources to choose not to read them, Dr. Moriarty stated, "I think it would be. All I can say is it would be strange not to investigate." She also agreed that if a physician had the data and a patient's family requested that ivermectin and MAF Plus be administered, assuming the physician knew the patient wanted it, the standard of care would be to investigate further, and it would be a breach of the standard of care for a physician to choose not to investigate unless they had some good reason not to at least examine the data. Even Dr. Lutzier himself acknowledged that under the College of Physicians and Surgeons of Ontario's policies and guidelines, there is a prescribed duty to see out new evidence and knowledge, to share this knowledge with others, and to apply it in practice. This was not a question of urgency. A total of 11 days elapsed between Dr. Strange forwarding the literature and Ms. Stark's death. Dr. Moriarty stated that she would be confident in deciding whether to administer the treatment after reviewing the literature for 3 to 5 hours. Dr. Lutzier had the time. Having admitted to only reading one of the 64 studies concerning the ivermectin trials that were available, he had no good reason to not examine the literature to make an educated, evidence-based decision.
Mr. Lee, I have a question. What are the limits of the standard that you propose? You're saying that it took the expert 3 to 5 hours to look at it. Must a doctor, in order to meet the standard of practice, read anything that's put to them at all, no matter what the source? What if the source is not a reliable source, in their opinion?
Yes, so I don't think we're not suggesting that a doctor must administer every treatment that's ever being recorded in a piece of medical literature, or that or advocating for a perfect outcome in this case. We see this case as very different. Dr. Lutzier in this case knew that the defendant wanted ivermectin and MAF Plus to be administered, and he was in contact with the patient's physician who was requesting that it would be administered. And we would remind the court that it was Dr. Lutzier who requested that this information be provided. So we see this case as being very different because he requested that the information be provided and he had it available to him. And I would just reiterate that the defendant's expert specifically stated that when a physician has access to those resources, that it would be a breach of the standard of care not to review them. Did that answer your question?
Thank you.
So instead, Dr. Lucier let his personal views about the treatment get in the way of his obligation to the patient. As the testimony established, his conduct did not meet the standard of care expected of a reasonably prudent practitioner. We also submit that Dr. Lucier breached the standard of care by denying Ms. Stark treatment with MAC+. Canadian courts have consistently held that an exercise of reasonable care in the medical context requires sound and thorough investigation of the patient's condition. Writing on behalf of this court in Crawford and Penny, Justice Power noted that the proper exercise of judgment by a physician is one that is made after his or her weighing, assessing, and evaluating such information as may be available. The information upon which a judgment or decision is reached must be as complete as is reasonably available and possible in the circumstances. Justice Henderson expressed a similar sentiment in McGregor and Potts, stating that clinical judgment is not guesswork based on limited facts. Clinical judgment must be exercised only after the medical practitioner has informed himself of all the relevant facts, subject to any time constraint. I would like to briefly set out the facts of that case as we believe they are relevant to the present matter. The defendant physician was found negligent in his decision to make a forceps intervention during labor. Prior to making the decision, he did not read the labor progress reports, flow sheets, or the nurse's notes, and he did not ask about the rate of descent of the baby. Justice Henderson held that having failed to inform himself, the defendant was not in a position to exercise his clinical judgment in favor of a forceps intervention. Further, he held that had the defendant informed himself, it was not in the scope of his clinical judgment to recommend the use of forceps. Prior to denying Ms. Stark treatment, Dr. Lucier did not inform himself of the improvement in her condition while receiving treatment with MAC+ and ivermectin, nor did he conduct any due diligence to determine the safety and efficacy of the treatment. Having failed to inform himself, he was not in a position to exercise his clinical judgment when deciding to withhold administration of the treatment. Moreover, we submit that had he been fully informed, it was not within the scope of his judgment to deny treatment. The literature provided by Dr. Strange illustrates that COVID-19 patients treated with MAC+ have a reported 6.1% hospital mortality rate compared to the average hospital mortality rate of 23%. The ivermectin meta-analysis establishes that in 78 studies involving almost 86,000 patients, there is an average 64% improvement in the patient's condition. The defendant's expert, Dr. Moriarty, stated that she would be comfortable prescribing ivermectin after reading 5 RCTs, showing beneficial results, safety, and effectiveness. In total, there are 33 RCTs involving 7,100 patients, showing an average 56% improvement. Meanwhile, remdesivir, which is part of the hospital's protocol in which Dr. Lucier administered to Ms. Stark, was approved after only 1 study involving 1,063 patients with an average 31% improvement. I've already discussed the effectiveness of ivermectin, so let me briefly address safety. In a study combining results from trials including over 50,000 patients, serious events occurred in less than 1% and were largely associated with administration in Loa Loa, a parasitic worm not found in Canada. Dr. Lucier suggests that ivermectin carries a risk for liver failure. However, there are only 2 cases of reported liver injury associated with ivermectin, both of which resolved without the need for treatment.
Counsel,
I'm sorry,
I have a question.
Yep.
While you're making submissions with regards to the safety of the alternative treatment, your friends have suggested that the standard is supportive care and that there was nothing inherently wrong with the treatment that was offered. How do you address that?
Yes. So again, I think it goes back to the fact that Dr. Luthier had these resources available to him. And I was actually just about to state it, but based on the studies that I just discussed, the defendant's expert, Dr. Moriarty, stated that it would be a breach of the standard of care to disregard alternative treatment in the face of positive and favorable evidence. So our submission is that based on that evidence that I just stated and the statement of the defendant's expert, it is a breach not to have administered the treatment.
Can I just follow up on that?
Yep.
It seems to me that the main argument being made is with respect to the obligation to review the literature. But the more pertinent question is sort of the second one. Regardless of whether or not the standard of care with respect to reviewing the literature has been met, it seems to me this might be a situation where there's perhaps different approaches that are all within the standard of care. So the literature point doesn't quite connect with the second question. So what do you say to that? The sort of almost the question of causation in the context of standard of care, if that makes sense.
Yeah, so I guess what we're saying is that the way we're connecting the literature to the administration of the treatment is to say that had Dr. Luthier read the literature and being fully informed, based on the evidence that is presented in the literature, it's our submission that he would not have been in a position to exercise his clinical judgment in favor of denying the treatment.
So the only thing he would have done or could have done after properly reviewing the literature would have been to administer the ivermectin. There was no alternative course of action that was within the standard of care. Is that your position?
It is, yes, and we're basing that on the defendant's expert statement that it would be a breach of the standard of care to not administer alternative treatment in the face of positive and favorable evidence. And we're saying that based on these studies, and I'll just reiterate 78 studies with almost 86,000 patients showing 64% improvement, and the low risk of adverse effects of the treatment, that it would have been a breach to just simply disregard this treatment had he been fully informed. Thank you. So, given the evidence in the literature, the only reasonable exercise of Dr. Luthier's clinical judgment was to continue to administer the treatment. That concludes my submission. Subject to any further questions, I will pass it over to my co-counsel, Ms. Dowling, who will address the remaining two questions in issue. Thank you for your time, Justices.
Can I ask one question before we move over to your colleague? I want to ask you about the quality of the evidence. So the evidence being the 64 articles. So if I said to you, I have 100 papers that say eating jelly beans will cure COVID-19, and they all come from Twitter or TikTok or YouTube videos, versus 5 articles that say jelly beans do not cure COVID-19, and they are reputable papers, published, peer-reviewed, well-established processes involved in studying that. To what extent does quality trump quantity? 64 articles, one might look at those very quickly and disregard them in a matter of minutes without having to sit and read through them, versus having to sift through this time when you're already very familiar with the information, with the standard of care, with the protocols. What are your thoughts on that?
Yes, so there's a couple things I'd say about that. The defendant's expert reviewed the literature, and she said that it really piqued her interest, and that she said there was links to all the studies, and it seemed like it was a reputable, I'm referring to the meta-analysis right now, but it seems like it was a reputable literature And then I don't have the exact numbers at the time. As you said, there was 64 studies at the time, but the meta-analysis is updated daily. But as of now, of the 78 studies, 58 of those are peer-reviewed. And the meta-analysis indicates that 63 of those 79 studies would have to be excluded to avoid finding any statistically significant efficacy. So our position is that given the vast amount of studies and the amount that would need to be excluded, that these sources are reputable. Thank you. Are there any further questions? Okay, I'll pass it off to my co-counsel. Thank you.
Thank you, Mr. Lee, and good afternoon, Justices. As my colleague mentioned, I will be addressing why Dr. Litzire's conduct did contribute to Ms. Stark's death and why West Valley Memorial should be held vicariously liable for this conduct. I will address the issue of causation and explain why the facts, the scientific literature, and the expert evidence all point towards the inference that Ms. Stark would not have died if Dr. Litzire had continued to administer MAP+. I will then assess the issue of vicarious liability and explain why Dr. Litzire's employment status, his character at the time of the incident, and the policy reasons all support the conclusion that we should hold West Valley Memorial liable for the incident. To begin, in order to assess causation, we use the but-for test. Would the plaintiff have suffered the same injuries but for the negligent acts of the defendant? In this case, we submit to the court that Ms. Stark would not have died but for Dr. Litzire's actions. When determining causation in the medical context, the law does not require scientific precision. Causation should instead be determined on the balance of probabilities. The Supreme Court of Canada held that the law can bridge a small factual gap in order to infer causation. And so I would bring the court's attention to paragraph 50 of our factum, where this was adopted in Gassi and Singh. Here, the court held that a judge is open to infer that should a treatment have been administered at an earlier point, this would have prevented the harm suffered by the plaintiff. In the present case, we submit that had MAP+ been administered continuously, it similarly would have prevented Ms. Stark's death. This is a reasonable inference. When Ms. Stark was administered MAP+, her condition improved substantially. When Dr. Litzire withheld MAP+, her condition deteriorated rapidly. It seems as though MAP+ was helping Ms. Stark greatly. In addition, the peer-reviewed literature available also supports this conclusion. When treated with ivermectin, one of the ingredients in MAP+, early improvement rates are 16.3% higher, clinical deterioration rates are 9.1% lower, and mortality rates are 16.9% lower. We also have expert evidence provided by Dr. Titchener and Dr. Strange, who stated that administering MAP+ was the standard of care. And they both suggested that if Dr. Litzire had met this standard, Ms. Stark's outcome would have been different. Therefore, based on the facts, the scientific literature, and the expert evidence, it is reasonable to bridge this factual gap and infer Ms. Stark would not have died if Dr. Litzire had continued to administer MAP+. It is also reasonable to bridge the factual gap that had Dr. Litzire read the studies sent to him by Dr. Strange, he would have been convinced of the efficacy and safety of MAP+. The defendant's witness, Dr. Moriarty, stated that she only needed to read 5 randomly controlled studies regarding ivermectin for her to be convinced of its effectiveness. Considering how data-driven Dr. Litzire has made himself out to be, it is reasonable to assume that he would have been similarly convinced. But for the defendant's actions, it is reasonable to assume Ms. Stark would have been continuously administered MAP+, and her condition would have continued to improve accordingly. Now I would turn the court's attention to our final issue. Is the hospital vicariously liable for Dr. Litzire's actions? We submit that West Valley Memorial should be held vicariously liable for his
counsel, before you get to vicarious liability, if we accept your approach to causation, aren't we essentially doing away with the need for the plaintiff to actually prove causation? Aren't you when what you call the factual gap, isn't that simply asking the court to ignore the fact that you haven't met the standard or the burden of proof to actually demonstrate that the administration of this treatment actually would have saved the life of the patient. And if that's the standard, then are we not now redefining negligence so that it's only a question of the breach of the standard?
We're suggesting that based on the fact that Ms. Stark was very rapidly improving and she very quickly deteriorated after the administration of MAC Plus and ivermectin, we feel as though that is compelling enough in order to assess that withholding ivermectin was a breach in the standard, yes.
How do you address the argument that that's just calling a temporal relationship causation? It's correlation, not causation.
So to support that, based on the literature that we have available, all the studies that my co-counsel had mentioned, that supports the idea that it wasn't just a correlation. It wasn't just that it really was that the treatment that we're referring to was helping Ms. Stark and that she wouldn't have died if she had been continuously administered that treatment.
Thank you.
Thank you. So now I would like to turn the court's attention to our final issue. Is the hospital vicariously liable for Dr. Litzire's actions? We submit that West Valley Memorial should be held vicariously liable for his negligence because he was an employee and he was working in the scope of his employment at the time of the negligent action. This is evident from his employment contract, his ongoing relationship with the hospital, and his hesitancy to deviate from the hospital's treatment protocol. The Supreme Court in Yepperman and Scarborough General Hospital held that a hospital is vicariously liable for a doctor's negligent acts only if they are a permanent employee of the institution. Accordingly, prior jurisprudence has not held hospitals liable for the actions of non-employees. Therefore, it is important to distinguish between an attending specialist staff retained by the patient to provide a service and an employee of the hospital. In the present case, Dr. Litzire was an employee of the West Valley Memorial Hospital. This is according to both his employment contract and in his discovery, where he admitted that he performs medical services on behalf of the hospital. Therefore, Dr. Litzire would not be considered an attending specialist staff retained by the patient to perform a service. In fact, Dr. Litzire made it very clear in his discovery that Ms. Stark did not choose him as her physician, but instead he was assigned to care for her by the hospital. Therefore, as an employee of West Valley Memorial, Dr. Litzire's negligence is also their responsibility, and they should be held vicariously liable for his actions. It is also important to determine if Dr. Litzire was acting in the scope of his employment at the time of the negligent acts. We submit to the court that he was, and consequently, the hospital should be held liable. The Supreme Court has ruled that when assessing liability, it is important to determine the character of the defendant's employment at the time of the negligent act. It was held that it is a safer practice to determine if at the time the defendant was acting within the ordinary scope of their employment or if they were outside the direction and control of the hospital. In the present case, Dr. Litzire was acting in the scope of his employment at West Valley Memorial. He himself designed the hospital's standard protocol set out in their COVID-19 treatment plan. And in his discovery, he admitted that he did not deviate whatsoever from the standardized protocol. He stated that he does this kind of work on a daily basis and gave no indication that he treated Ms. Stark any differently from all of the COVID patients he had treated at the hospital before. So his negligent actions did not deviate from what West Valley Memorial expected of him, and he was clearly acting within the ordinary scope of his employment. Furthermore, we submit to the court that this hospital should be held liable for policy reasons as well. It is in all of our best interests for doctors to be good at their jobs. And although that clearly requires a degree of autonomy, it also means that they need to be given accurate instructions for what to do when they're seeing patients. Obviously, things will pop up, such as COVID-19, that nobody learned about in medical school. And when those situations arise, we need to be able to trust our hospitals to curate the best treatment plans possible. West Valley Memorial appointed Dr. Litzire to create their COVID plan, and they entrusted him when deciding exactly what happened every single time a COVID patient walked into that building. They are responsible for a treatment plan that was developed by a doctor who couldn't be bothered to read a study that was directly sent to him by another physician.
Counsel?
Something that yes.
Forgive the interruption. I have a question. Is it necessary at all to establish any separate negligence or oversight on the part of the hospital? You're making submissions now on the policy reasons, but really there's no evidence of oversight or direction or that the hospital was aware that the protocol was defective in any way. Is that a necessary component for your argument?
We submit that that's not a necessary component, that simply being an employee acting in the scope of his employment was enough to hold the hospital vicariously liable. And on top of that, the fact that they appointed Dr. Litzire to create the standard of care that he followed, we think that that is further evidence that they should be held vicariously liable.
Thank you.
West Valley Memorial appointed Dr. Litzire to create their COVID-19 treatment plan. They entrusted him with deciding exactly what happened every single time a COVID patient walked into that building. They are responsible for a treatment plan that was developed by a doctor who couldn't be bothered to read a study that was directly sent to him by another physician, something that even the defendant's witness admitted was a breach in the standard. We should not allow that to go unpunished. Yes, Dr. Litzire should be held liable for his negligence, but West Valley Memorial should also be held responsible as they place a doctor in charge of creating a treatment plan who doesn't believe in taking a look at peer-reviewed studies that a fellow physician begged him to read. Not holding the hospital liable sets a dangerous precedent. Hospitals need to be diligent when entrusting physicians to curate treatment plans. We should encourage them to appoint physicians who are open to all scientific perspectives and take the time to read peer-reviewed studies that disagree with their opinion. They need to be open to changing their minds. By holding West Valley Memorial liable for Dr. Litzire's negligence, we are encouraging other hospitals to take more care when curating treatment plans, which will make all of us safer in the future. To conclude, we submit that the defendant was negligent in his actions towards Ms. Stark. He owed a duty of care and breached the standard of care of a reasonable, prudent physician. It is unreasonable for a prudent medical practitioner to blindly follow and cast aside other methods of treatment as propaganda when that protocol has proven ineffective. It is also unreasonable that he denied Ms. Stark treatment with Math Plus, as he did not thoroughly investigate her condition. By failing to inform himself, he was not in a position to exercise his clinical judgment when deciding to withhold administration. We submit that these breaches in the standard greatly contributed to Ms. Stark's death. Based on Ms. Stark's rapid improvement on Math Plus and her quick deterioration when the treatment was withheld, combined with the scientific literature and expert evidence, it is reasonable to bridge the small factual gap. We therefore conclude that but for Dr. Litzire's negligence, Ms. Stark would not have died. Finally, we submit to the court that West Valley Memorial should be held vicariously liable for the death of Ms. Stark. As an employee acting within the scope of his employment, Dr. Litzire was their responsibility and they should share liability for the incident. It is also important to set a precedent that will encourage hospitals to keep us safer in the future. For these reasons, the plaintiff respectfully requests that the court award non-pecuniary damages for the death of Ms. Stark due to the negligence of Dr. Litzire. Subject to any further questions, this concludes our submission. Thank you.
The court now invites the defense counsel to speak.
Good morning, Justices. My name is William Wang. Together with my co-counsel, Malik Tehaili, we represent the defendants, Dr. Litzire and West Valley Memorial Hospital. In the case before us today, we have put a frontline hero at trial for performing his duties and exercising evidence-based care and treatments accepted throughout Canada. This is also a case about whether information from internet and social media should shape the standard of care over industry standards approved by major health agencies. During this trial, I will argue Dr. Litzire did not breach the standard of care. My co-counsel will argue there was no causation between Dr. Litzire's conduct and Ms. Stark's death, and West Valley Memorial Hospital is not vicariously liable. I will begin with defendant's first submission that Dr. Litzire did not breach the standard of care by failing to investigate the information he was provided with or denying either ivermectin or Math Plus. I will present the requisite standard of care for medical negligence in Canada as correctly applied to this case, then apply to each of Dr. Ladner's actions. I begin with defendant's factums, starting at paragraph 20. We accept that the duty of care and the definition of standard of care for medical negligence raised by our friend. The Supreme Court in Terneuzen and Korn also stated a physician must exercise the degree of skill of an average specialist in his field who possess a reasonable level of knowledge, competence, and skill. However, my friend has not mentioned the importance of custom in standard of care. The court in Keys and Abraham has articulated that where a common and accepted course of conduct is adopted based on the specialized and technical experts of professionals, it is unsatisfactory for a finder of fact to conclude that such standard was inherently negligent. The Supreme Court of Canada has recognized in La Pompe.
Could I just stop you? I just have a question about that specific point, and the one I was thinking about. So the custom being important in context of standard of care, I understand that, but what role does that play in a situation like this, where it's a novel coronavirus, a new, obviously new threat? This is not casting a wrist or, you know, or dealing with something like diabetes that's very well known and has been around forever and ever and ever, but it's something that's very new, that's very emerging, and that, you know, is there a different approach there in terms of the role custom or sort of established practices would play in the context of COVID-19? Does that come into it?
Thank you, Your Honor. So to answer your question, I have 2 points. So number one, we recognize that physicians do have a duty to not harm their patients, and they do have a duty to stay up to date with all the relevant information. But however, in this case, in the treatment of COVID-19, the evidence is overwhelmingly favoring supportive care rather than ivermectin. And as the defendant's witness has testified that such supportive care is what all the colleagues around Canada are using. And if we look at ivermectin, we have seen Health Canada has recommended against the use of ivermectin locally. The Ontario COVID-19 Science Table has also recommended against the use of ivermectin because of its, number one, the potential risks, and number two, the lack of benefits. If we look at BC, the BC Center for Disease Control has prohibited its registrants from prescribing such medication because of its concerns. So although COVID-19 is a novel situation, it is a disease that nobody has seen before. But however, medical community has reached a consensus that ivermectin should not be the industry practice. So moving back to standard of care, I have mentioned that if a common accepted course of conduct is adopted based on the experts of professionals, it is unsatisfactory for finder of fact to conclude such standard was inherently negligent. Additionally, the standard of care is not a standard of perfection, and standard of care is influenced by the degree of foreseeable risks. Having outlined the standard of care in medicine, we submit that evidence-based care and supportive care is the standard of care. As I just mentioned, with overwhelming evidence, it is clear that evidence-based care and supportive care are the industry standard. And just to reiterate, the court in Terneuzen in paragraph 51 has also agreed that it will not be open for a judge or jury to find a standard medical practice negligent unless it is lacking obvious and reasonable precautions, which are readily apparent to an ordinary finder of fact.
Counsel, but isn't it the case that your friends are not so much saying that the administration of the supportive care was negligent? It's the fact that the doctor was unwilling to administer their alternative care that cost her life. What do you say to that?
Thank you, Your Honor. To answer this question, number one, a physician is permitted to exercise their discretion in determining the best course of treatment for the particular patient. This has been seen in Keys and Abraham at paragraph 37. And again, while physicians do have a duty to adapt, the defendant's witness, Dr. Moriarty, has testified that it does not mean a physician must substitute what he or she is comfortable with that has minimal risk to another treatment with inherent risks. And she also testified that physicians have a duty not to do harm to patients, and she testified that she would not administer ivermectin. My friend is trying to look at the situation retrospectively by saying Dr. Ladner should have been administering ivermectin, which might possibly save her life, which my co-counsel will discuss that there is no causation. But however, we have seen in jurisprudence that we cannot look at a physician's conduct retrospectively. My friend has also attempted to paint a picture that ivermectin is somehow effective and safe based on the so-called number of studies available. However, I have to remind the court that the number of studies does not equal to quality. Many of the studies are confounded with no proper comparison to control groups and no specific dosage mentioned.
But counsel, you know that now because you've reviewed them. Isn't the issue that Dr. Lutzier didn't even take the time to review them and make a determination? Doesn't the standard require that at least a physician look at the available evidence and make a considered decision?
Thank you. Although we recognize that physicians have a duty in general to be up to date with the most current medical information, and Dr. Moriarty feels it might be worthwhile to investigate, she also testified that if the physician already knew about the studies or had enough evidence to refute them, investigation would not be necessary. Dr. Ladner has followed the industry-accepted practice of evidence-based care, and he made an informed decision, as can be seen by his request for Dr. Strange for the relevant information. However, those information had to be dismissed, as it consists of sources from non-peer-reviewed websites to social media, such as Twitter and Odyssey. Since a reasonable physician would not obtain information from even sources such as news channels like CNN, a physician is merely conforming to the industry practice and standard of care when it dismisses some of the information Dr. Strange has sent. Additionally, Dr. Ladner is actually well equipped with enough evidence in the treatment of COVID-19 to make an informed decision, as can be seen by his collaboration with allied health professionals in drafting the COVID-19 guidelines. Contrary to my friend has suggested, Dr. Ladner did not create this guideline himself. This is a collaboration with infectious disease, pharmacy, science, other scientific researchers, and by reviewing all the relevant recommendations from FDA, CDC, and Health Canada. Additionally, Dr. Ladner has been staying up to date by meeting with his team monthly to review the new studies available. Forcing Dr. Ladner to investigate over 100 studies independently during the middle of a global pandemic and critical care setting will be holding a physician to a standard of perfection. So to summarize, in the face of established industry standards, regulations, and potential harm of ivermectin, would a reasonable, competent physician in the circumstance with similar experience and knowledge administer ivermectin? Not to mention, ivermectin has not been studied in critical care COVID-19 patients. The risks are unknown, but the consequence can be severe, such as seizure, hypotension, coma, and even death. In the face of these potential risks, we submitted that a physician in the same circumstances with similar experience, knowledge, and information from the public health and regulators would not administer ivermectin or look at the information Dr. Strange has sent, exactly as Dr. Ladner performed. Although my friend would argue physicians has a duty to investigate all studies independently, as the studies, some of them are peer-reviewed as they claim. Again, we would state that investigating all studies individually is holding a physician to the standard of perfection. Before handing off to my co-counsel, I would like to close by reminding the court the importance of evidence-based practice and regulatory oversight in the medical field. Practicing medicine without such oversight has led to tragedies like the thalidomide crisis. And if the court does not have further questions, I will pass on to my co-counsel.
Good morning, your justices. My name is Tehaili, and I will be dealing with the second two issues on causation and vicarious liability. I have 2 points on submission. First, the plaintiff is unable to meet the but-for test of causation as Ms. Stark had already entered the pulmonary stage of COVID-19. And second, it cannot be established that West Valley Memorial Hospital is liable for Dr. Lutzier's actions as there was no act of negligence. Beginning with the first point, your justices, the but-for test of causation has not been met. The plaintiffs are unable to show, as a matter of fact, that the loss suffered by Ms. Stark would not have occurred but for the acts of Dr. Lutzier. In Edgar versus Johnston, in paragraph 28, the court describes that when it is found that a defendant's role was not a necessary condition to produce the harm suffered by the plaintiff, they must be barred from all liability. Further, the Supreme Court of Canada asserted in Hank versus Resurface Corporation that the but-for test of causation ensures that a defendant will not be held liable for the plaintiff's injuries where they may very well be due to factors unconnected to the defendant and not the fault of anyone. And that is what we see today. It cannot be asserted that Dr. Lutzier had any role in Ms. Stark's injury as she already entered the pulmonary stage of COVID-19. As illustrated by Dr. Lutzier on page 87, line 18 of the record, sometime between when Ms. Stark entered the hospital and before Dr. Lutzier assumed care of her, she had already entered the pulmonary stage of COVID. This means that she developed advanced fibrotic lung disease arising from her body's overwhelming inflammatory response. And this is what ultimately led to her death. Fibrotic lung disease is a hallmark of ARDS, and according to the CDC, the mortality rate for these patients ranges up to 72%. The statistics for patients who have developed ARDS is grim, but even if Dr. Lutzier continued to administer ivermectin or MAP plus protocol, the injuries occurring prior to and resulting in her death could not have been reversed. It was actually a possibility that it could have done more harm. There have been multiple poison control and toxology reports that were sent to Dr. Lutzier, showing cases of ivermectin use followed by severe adverse reactions. And these include seizure, shock, or hypertension. Based on the vast evidence that the administration of ivermectin is dangerous, Dr. Lutzier made the responsible decision to not continue with ivermectin or MAP+. Instead, he chose to look to the standard of care established in Canada, which has been described as supportive care. It is clear that the risks of administering ivermectin and MAP+ outweigh any type of benefit it could have had. Further,
Sorry, I just have a question, and one thing that I wanted to ask that I think sort of jumps out on the facts is, and correct me if I'm wrong in terms of the way I recall the facts, but my understanding was that there was a decision to re-administer the ivermectin after she had crashed, and then she sort of rallied, and then there was again the withdrawal of the ivermectin, after which she then crashed again. Is that, first of all, is that accurate in terms of the general description of her course?
Yes.
Okay, so my question is, how do you address that? The sort of the kind of the obvious causation problem in that instance that seems to suggest that to the extent she was an ivermectin, she was doing great, and to the extent it was withdrawn, she wasn't.
Thank you, Your Justice. And although we have seen that when there was a correlation between every time in which ivermectin was administered and Ms. Stark's condition improved, I'm going to remind the court today that correlation does not equate to causation. And this is because there's other confounding variables which are not accounted for when we just look at two things, A equals B. And that's why we can't do that today. Further, it would possibly be negligent.
Like, what are the variables, right? Like, so it's like, you know, and maybe that's not in the evidence, but sort of, if, you know, it's like, it's, there sort of has to be a step two to that, right? Like, and here's what they are. So just sort of in terms of what would have happened had she stayed on, you know?
Yes, thank you, Your Justice. Although I can't speculate what would have happened, I can't say she will get better. I can't say she won't get better. However, what I can say is that typically in a study, the reason we can't equate correlation to causation is because there's always some other factor, some other thing that needs to be accounted for to 100% make sure that A is equaling to B, that ivermectin was the thing that was making her better. Further, it's been shown that ivermectin is not used to improve the health of patients with COVID. So I can't assert today that the correlation between her getting better and the administration of ivermectin was the causation. I hope that answered your question. Thank you. Moving back into the pulmonary stage of COVID and why Dr. Lucier chose to stop administering the ivermectin. The CDC has illustrated that the only valid treatment for patients in this stage is supportive care. And this is a standard in Canada and the standard at West Valley Memorial Hospital. Further, it's evident that Ms. Stark's death was caused by the onset of severe COVID-19 symptoms and not the treatment administered by Dr. Lucier. With respect, the court today would be doing a grave disservice to every medical professional who's worked on the front lines if it was found against the clear evidence that Dr. Lucier had a role in causing Ms. Stark's injuries. Moving forward, I'm gonna state some of my friends' arguments and why they failed to show causation. To begin, my friends have relied on the holding in the Gervais case when asserting that an inference can be made on causation. However, they've done so out of context. My friends neglect to mention that at paragraph 22, the court in Gervais asserted that they were only able to make this inference because the appellants called no expert evidence on causation. However, both Dr. Moriarty and Dr. Lucier have presented evidence to the contrary. Moving forward, my friends point to Dr. Lucier having access to the relevant literature and still choosing not to treat Ms. Stark with ivermectin and MAP plus protocol as a cause of her death. However, I ask the court today, would a reasonably prudent and diligent physician refer to Twitter or other social media sites as literature to make a decision about a critically ill patient? How could Dr. Lucier be expected to administer an experimental drug with evidence from Twitter? And the plaintiffs may argue that more links and more literature were sent. And while this is true, they failed to mention that the other links, like the meta-analysis, was not published in any reputable journal. Many of the RCTs don't even specify dosages, like the ARIF trial conducted in Egypt, or that some trials reported major inconsistencies, like the Gonzalez trial conducted in Mexico. The plaintiffs may also point to the study sent by Dr. Strange, but they'll neglect to mention that the researchers in that study admitted that it was not standard of practice for data from preprint servers to influence therapeutic practices. My friends have stated that it is compelling enough to bridge a gap. However, they neglect to mention a key confounding variable in this case. Ms. Stark had already entered the pulmonary stage of COVID-19. I'm going to move on to my second point of vicarious liability.
Counsel, before you do, may I ask a question? Your friends have also stated that part of the deficiency in the physician's approach is that he ignored the evidence of her recovery. To what extent then is causation able to be tied into the fact that he completely ignored the evidence of her recovery, regardless of stage, and simply defaulted to what he considered to be the standard protocol?
Thank you, Your Justice. Although I can't speculate what was going on in Dr. Lutzier's mind, why he chose not to look specifically at that progress, I do know two things. One, I know that Dr. Lutzier had previous knowledge about ivermectin and the adverse risks that it comes with. And I know that Dr. Strange sent him the relevant literature because Dr. Lutzier asked her for it. He was open to looking at other options and he was open to looking at ivermectin even. However, he had to reject that information because some of it came from social media sites or poor quality journals. So with that in mind, I do know he had some reasons against ivermectin use. Thank you. So again, moving on to vicarious liability, generally for a physician who's salaried and employed by a hospital, the hospital may be held vicariously liable for negligent acts and faults carried out by the physician. However, in Yepremian versus Scarborough General Hospital, the Court of Appeal held that because hospitals don't control clinical decisions, this makes physicians independent contractors and the hospital should not be held vicariously liable. It must also be noted that when there has not been a breach of the standard or duty of care, vicarious liability must not be imposed on, by the hospital. As articulated by the Supreme Court in Baisley, the test for vicarious liability is not to be applied mechanically. Rather, the evidence is to be analyzed with the policy goals of fair compensation and deterrence in mind. Courts have strived to be fair and reasonable when determining whether a hospital is vicariously liable for the wrongful acts of an employed physician. When my friends submitted their issue on vicarious liability, they suggested that hospitals should ensure that their doctors are good at their job. However, to assert that a frontline hero couldn't be bothered to read literature sent to him is wrong according to the facts. As I've previously stated, it was Dr. Lutzier who asked Dr. Moriarty to send him the relevant literature. However, based on his previous knowledge, he decided to reject personal opinions from Twitter or patient testimonies from Odyssey. Dr. Lutzier was open to other options. However, he wasn't open to medical opinions from Twitter. As my co-counsel and I have illustrated, the standard of care for COVID-19 patients in Canada, as supported by the CDC, the FDA, and Health Canada, is supportive care, the same supportive care that was applied to Ms. Stark. As Dr. Lutzier did not break the standard, he did not act negligently, the issue of vicarious liability becomes immaterial. To conclude, the defendant respectfully requests an order to have all claims of negligence against West Valley Memorial Hospital and Dr. Lutzier dismissed. As Dr. Lutzier did not breach the standard of care for COVID-19 patients, his acts were not the cause of Ms. Stark's death, and West Valley Memorial Hospital cannot be found vicariously liable. There has been a long history of courts upholding a standard that when a physician applies the accepted standard of care established by the medical community, the physician may not be held liable for adverse outcomes.
Counsel, can I stop you for 1 second? Is the issue different in circumstances like this where you've got the patient and or her substitute decision maker arguing against the treatment that's being made and in favor of the alternative treatment? And I would add to that, you yourself have said it was sort of a foregone conclusion because she was already in the more serious stage. So at that point, wouldn't the standard suggest that you kind of try anything, throw all the spaghetti against the wall? Isn't it different in those circumstances?
Thank you, Your Justice. In circumstances where the doctor has applied and done everything he could, although some might argue that you should do more, we can't just assume that we're going to try anything that could work if there would be adverse outcomes. For example, Dr. Lucier had previous knowledge on ivermectin and the inherent risks that come with it. Although I can't speculate what he was thinking, it would be reasonable to conclude he didn't want to cause more harm to Ms. Stark by administering ivermectin that he believed was dangerous to her. Thank you. Going back to my conclusion, as a matter of public policy, it would be unjust to uphold a standard of perfection upon Dr. Lucier, especially in the midst of a pandemic arising from a novel virus. We urge the court to remember that supportive care is the standard of care. Subject to any further questions, that concludes my submission. Thank you.
The court now invites counsel for the plaintiff to begin their 3-minute optional rebuttal.
Thank you. There's just a couple of points that we wanted to make. So to begin with, our friends state that it was not a breach of the standard of care for Dr. Lucier to choose not to review the literature because the information provided to him by Dr. Strange linked to unreliable sources such as social media. We would respectfully submit that that misrepresents what Dr. Strange sent. The main components of her email were a Math Plus analysis developed by 10 medical professionals and an ivermectin meta-analysis reviewing 78 ivermectin studies, 58 of which were peer-reviewed. We would remind the court that the defendant's expert, Dr. Moriarty, specifically stated that if a doctor had access to those resources, it would be a breach to choose not to read them. Our friends also submit that Dr. Lucier had reason not to review the studies because they were of low quality. The problem we have with that argument is that how could Dr. Lucier know the studies were low quality when he chose not to read them? The final point we would like to make, our friends submit that asking Dr. Lucier to read all the studies would be holding him to a standard of perfection. We would suggest that there's a major difference between reading all the studies and choosing not to read any of the studies and casting them aside as propaganda. We would also remind the court that the defendant's expert, Dr. Moriarty, stated that she would be comfortable deciding whether to administer the treatment after 3 to 5 hours. We submit that this is far from a standard of perfection. That concludes my reply. Thank you, Justices.
Can I ask a quick question?
Yep.
So why isn't it sufficient for a physician to rely on the leaders in the field, the CDC, the FDA, the Health Canada? One can assume that they have taken the time to read everything that's out there. And if they, having done that, have said, no, we're going with supportive care and not this, why should the standard hold a physician to sort of more investigation and to depart from what the leading science tables and the leading experts in this field have determined?
Yeah, I think our answer to that would be that COVID is such a new disease that it's rapidly adapting, and science tables are continually updating what they would recommend. And I would just remind the court in this case that there was disagreement between the experts, and the doctor knew that the patient and the patient's physician thought that ivermectin and Math Plus should be administered, and that it was the doctor Dr. Lucier, who asked for this literature. So in that case, we submit that it is entirely reasonable for a physician to review the literature and to administer an alternative treatment. And something that came out in the record during Dr. Lucier's discovery was that he has himself administered drugs off-label in the past. And he, although not knowing the exact number, he said that it sounded right to administer drugs off-label, that off-label drugs are used in practice 20 to 40% of the time. So this is something that is not really new. Doctors are constantly seeking out alternative treatments when the standard protocol is not working for their patients. Does that answer your question, Justice?
Thank you.
Thank you. Are there any further questions?
Yeah. To what extent is it reasonable or necessary for a physician to act on the recommendations of an external person, be that a patient or relative, another physician, an external provider? Because one could spend their whole life, taking advice from external forces if you took it to the nth degree. Where is the line there, do you think?
I think the line is, again, to rely on reliable studies. And again, I would just like to stress that we're not suggesting that a doctor has to seek out every treatment that's ever been cited in a journal. We're just stating that this case is very different in the sense that the defendant himself knew that the patient wanted the treatment to be administered, and he asked the defendant's physician the patient's physician to forward him these resources. So we're not saying if a treatment protocol isn't working, go out and just administer everything that's been cited in every journal. We're just saying the facts of this case are very different, and that the experts all agreed that when you have a reputable physician like Dr. Strange forward you literature and ask you to read it, that it's a breach not to read that literature. Did I answer your question, Justice? Thank you. Are there any further questions? Thank you.
This concludes the matter of Stark and Moutier.